Well, let's get started.
Yay.
Hey. So welcome everybody. My name is Elizabeth Aloni and I'm with Schneps Media. We are the largest local media company in New York City. We publish over 70 newspapers, magazines, websites across Manhattan, Queens, Brooklyn, the Bronx, Westchester, and Long Island. We host over 50 events a year, and we're moving to do some of those as virtual events, which are going to be exciting. And we do podcasts, and as you see here, webinars, where we look to bring you some of the most important topics from the top experts in New York City. Today, we're thrilled to have Laura Cowan to share with us estate planning secrets. So welcome, Laura.
Thank you.
To have you here. Let me please tell everyone about you. Laura Cowan, Esquire, a CPA, is the founder and owner of the law office of Laura Cowan, a boutique law firm located in Midtown Manhattan. Laura prepares comprehensive estate plans, including wills, trusts, guardianship, healthcare proxies, powers of attorney, and asset protection, all for a flat fee, pre-selected by the client. Wow. Laura is a former CPA with experience at Ernst & Young and Goldman Sachs. Her firm has over 50 five-star reviews across Google, Yelp, and Avvo, and she's been ranked the second best estate planning attorney in New York by Yelp out of over 800 lawyers. Laura was named a Super Laura Lawyer in 2019 and 2020, an award reserved for the top 2.5% of attorneys in New York, and was featured in the March 21-20 issue of the New York Times as a top woman attorney in New York. A frequent speaker and author on estate planning, Laura has presented at UN headquarters on estate planning for non-citizens and has been published in Forbes. When I told you we bring you the top experts, I was not kidding. Welcome, welcome, Laura. We're so thrilled to have you here.
Super. Thank you so much for having me. I'm here from my office at Grand Central in an enclosed conference room, so hopefully I'm safe, socially distancing. I'm going to go ahead and share my screen so we can pull up the presentation. Let me know if you can see this.
That looks great.
Okay. Okay, so estate planning secrets. Again, welcome to the webinar, Estate Planning Secrets, How to Protect Your Family with an Estate Plan. My name is Laura Cowan, as Elizabeth said, and I want to thank you for being on the webinar today. This is a really important subject. I know it's very top of mind these days, and people have a lot of concerns, so I'm really happy to be doing this and to be here to kind of go through my presentation, but also answer your questions. I'm anticipating a lot of questions, and I'm happy to stick around after the webinar and answer as many of those as possible. And I want to make sure that you stay throughout the whole webinar. I think we're going to go about maybe 25, 30 minutes, and then we'll have questions at the end because there's a bonus for each of you at the end that I don't want you to miss out on. So be sure to stick with me for the whole webinar because I want to make sure that you get that bonus at the end of the webinar. So Elizabeth did a great job introducing me. I just want to make sure that you've got my contact information, and this will all be coming out in an email after the webinar as well. And here's a little screenshot of the #2 ranking by Yelp. So we're definitely very proud of that. We're a boutique estate planning law practice based here in Manhattan. And estate planning is the only kind of law that we practice. So we do trusts and wills and guardianship and asset protection and all of the documents that you need, healthcare proxies to make sure that your assets and your family are protected no matter what. So, you know, this is why we're here today, to talk about what happens if something happens to you. You know, this is the main question for today. What will happen for your family and your assets and all of the things that you care about should something happen to you, if you pass away or you get sick or incapacitated. So, you know, estate planning is about both possibilities. It's not just about what happens if you pass away. It's also about what happens with your health care and your assets and your finances if you get sick or incapacitated and you can't manage those things on your own. So, you know, will things go smoothly, or is there going to be a big mess left behind for your family? So that's what we're here to talk about, and we'll make sure that you have answers to all of your questions before we go. So this is our agenda. First, if you don't have any estate planning documents in place, you might think you don't have an estate plan, but you really do. You've accepted the state of New York's default plan for you. So we're going to talk about what the state of New York's default plan is for people who don't have any of these estate planning documents in place. And we're going to talk about what that means for you and your family and your assets, and why you may want to opt out of the state of New York's default plan for you. And then we'll talk about the 3 legal documents that every adult should have. And so by adult, I mean anyone over the age of 18. And it's really important that you understand that these documents, they matter for everyone, no matter how old you are, no matter how much money you have. I want to make that really clear. And then you might be wondering why, can't I just do my estate plan online? Can I just fill out some forms on the internet? And I want to go over why that's not a good idea and what you might want to do instead. So you might be wondering, is this all going to apply to me? Do I really need to worry about having these documents in place? It's really common for people to think, well, I don't need estate planning documents because I'm not old enough or I'm not wealthy enough. A lot of people think that estate planning is only for people who have a lot of money. A lot of people who aren't married and don't have kids think that this doesn't apply to them. And you might also be thinking, I just don't have the time to deal with it. And that's a really common thing that I hear a lot as well, and they're understandably so. But again, if there's one thing that you should take away from this webinar, it's that everybody over the age of 18 needs these documents in place. And the reason for that is because, the goal of estate planning is, it's very simple. It is to make things as easy and inexpensive as possible on the people that you care about when you're gone, right? So it's about making sure that your family isn't left with a big expensive mess if something happens to you. Now, we all care about that. We care about that whether we're leaving $10 behind or whether we're leaving $10 million behind, right? You want things to be as easy and inexpensive as possible for your loved ones. We're all going to be leaving behind people who care about us. We're going to have to manage our affairs when we're gone. And that's what these documents are about. So, really estate planning, the thing to remember is that you're doing it for your loved ones. It's not for you, it's for the people that you care about. So let's just dive right into the 3 basic documents that every adult should have. And some of these may sound familiar, but I'm going to go through them anyway, just so you have a sense for what each one does. So first of all, a will or a trust. And we're going to talk about the difference between a will and a trust. A lot of people are confused about that, so we're going to go over that. But for now, just know that everyone should have a will or a trust. And this is where you get to name beneficiaries for your assets. So we all have assets, no matter how big or small. We all care where they go when we're gone. And so, with a will or a trust, you get to name your beneficiaries for those assets. Maybe you want to include a charity. You can write that into your will or trust. Maybe you want to add provisions that, you don't want your kids to get their inheritance at 18. I have yet to meet a parent who actually wants that. So maybe you can write into your will or your trust, that I want everything to go to my kids, but not until they turn 25. So a will or a trust is that first document that everyone should have, regardless of how much money you have. It's important to name those beneficiaries for your assets. And then second, everyone should have a healthcare proxy and something called a living will, which kind of goes along with the healthcare proxy. So this is now more important than ever, right? The healthcare proxy with this pandemic that we're all facing. So a healthcare proxy, it's a document where you name someone to make medical decisions for you if you can't communicate them yourself. And you can name a spouse or a sibling or a friend, anyone you trust to make those decisions for you on your behalf. That's what you do with a healthcare proxy. A living will conveys your end of life wishes. So this is where you get to put down your instructions and your wishes regarding your end of life care with life support and things like that. So you want to have that in place because, you know, without one, you're leaving your loved ones in this really hard position of having to make those end of life decisions for you, which is going to put them in a really tough spot, and without knowing what you would have wanted. So a healthcare proxy, a living will, no matter what age you are, you should have these, because as we know now, you know, anyone can get sick at any time, and you want to have these documents in place if you do. And then a financial power of attorney is the third document that everyone should have. This is where you give someone that you trust, like a friend or a family member, the authority to pay your bills and make financial decisions for you, file your income taxes, do all of those things with your assets that you might not be able to do if you're at the hospital, you're sick, you're incapacitated. So again, you know, you name someone that you trust and that you give them authority to make those decisions for you. And then fourth, if you have minor children at home, you definitely want to make sure that you've named legal guardians for your minor kids. I always say that if you're a parent and you've got minor kids at home, I think that estate planning is more important for you than it is anybody, because it's your job to name legal guardians in your estate plan, and these are the people that you would want raising your children if something happens to you. If you don't have an estate plan where you've named legal guardians, ultimately a judge is going to make that decision for you. So it's very important for parents of minor children to have these documents in place for that reason. So I'm guessing many of you on the call today don't have these documents in place, which is somewhat normal. So I want to go over what would happen without these documents, just so you get a sense for how kind of badly things can be if you don't have these documents in place. So, you know, let's say you get sick, you have to go to the hospital, you're not able to communicate your healthcare wishes. If you don't have a healthcare proxy in place, your family's going to have to go to court to get access to your medical records, to make medical decisions for you. They're going to have to go to a court to have a judge say, yes, it's okay for this person to make decisions on your behalf. So first of all, court is always expensive. It's always time consuming. And ultimately, it means that the wrong people could end up being in charge of your healthcare. So it could end up being an ex-spouse, a soon-to-be ex-spouse, or maybe your parents when you would have preferred your siblings. So, you know, that's bad. If you haven't named who you want to make these healthcare decisions for you, you don't want a judge making that choice for you. And then also ultimately, you know, you run the risk that decisions could be made that are not in alignment with what you would have wanted. So if you don't get your wishes down in writing, people just aren't going to know what you would have wanted, and you're putting your family in a really tough position. So it's very simple to have a healthcare proxy. You get that in place, you name the person that you want making those decisions for you and your backup if possible. And then you give that to your family members and all of your medical providers, and it's very easy to solve this problem, but it can be pretty messy if you don't have one. It's the same thing without a financial power of attorney. If you get sick, you go to the hospital, you're not able to pay your bills, maybe file your income taxes on time, things like that. Someone's going to have to make these decisions for you. Someone's going to have to do these things on your behalf. If you don't have a power of attorney in place, naming someone that you trust to manage your assets for you, your family's going to have to go to court again to access your bank accounts, pay your bills. That's going to be expensive and time consuming. And the wrong people could end up in charge of your money. And again, you run the risk that decisions are made that are not what you would have wanted. So it's easily solvable with this power of attorney. Again, estate planning is not just about what happens when you pass away. It's just as much about what happens if you get sick. Any of us could get sick at any time, no matter how old we are. And that's why these documents in particular are so important to have in place right now. So what happens if you pass away and you don't have a will or a trust? Well, you might think that you don't have a will, but you do. It's just that the state of New York has written it for you. So first of all, that means that your assets are going to be distributed to whoever New York state law says should get your assets. And that will depend on whether you're married or not, and whether you have kids. But whatever New York state law says, that's where your assets are going to go. So this may or may not be what you would have wanted. So for example, if you're married and you have children and you have any assets that are held in your name alone, and you pass away without a will, those assets will go half to your spouse and half to your kids. Well, a lot of parents don't want that. A lot of parents would want everything to go to their spouse. But that's what would happen if you don't have a will saying that you want everything to go to your spouse. So your assets will be distributed according to New York state law. A judge is going to assign an executor to oversee the distribution of your assets, and they're going to get a chunk of the estate assets for doing that work. If you pass away without a will and you've got minor kids, well, you've missed your chance to name guardians for your minor kids. So a judge is going to have to make that decision for you, and they could end up picking the last person you would ever want, and they'll have no way of knowing who you would have wanted. Another problem with that is you might have more than one family member who wants to be guardian of your kids. Maybe your family and your spouse's family both want to be guardian. Well, if you haven't named your choice of guardian in an estate plan, then ultimately you're going to have family members fighting over that, and that's the last thing that anybody wants. And then finally, if you pass away without a will or a trust, your family's going to be stuck in probate court. And some of you might be familiar with probate court if you've had a family member pass away. Probate court is basically the process of distributing someone's assets to their family when they pass away. So that's what probate court is. There's some pretty big downsides to probate court. First of all, it takes a long time. It can take as much as 12 to 18 months to distribute your assets to your family, and during that time, the assets are frozen. So that means that your family can't access them, which is a problem if you've got people relying on those assets to help raise your minor kids. Probate is expensive. It ends up costing about 5 to 7% of the estate assets. So that ends up being a pretty big chunk of money, and I'm going to go over a calculation here in a second so you can see what that looks like. Probate is a public process, so that means that anyone can go down to the courthouse and see what your assets were and who you left them to. So this bothers a lot of parents of minor children. They don't necessarily want people seeing that their minor kids are going to be inheriting a certain amount of money when they pass away. And then if you pass away without a will or a trust, your kids are going to get their inheritance at 18. And again, I've never met a parent who actually wants this. So if you don't want that to happen, you need to get a will or a trust and write into the documents, I want my kids to get their inheritance at 25 or 30 or however you decide, whatever age you think is appropriate. So let's look at how much probate costs. This is just an example. Let's say someone passes away and these are their assets. They've got real estate worth $500,000, a brokerage account with $100,000 in it. They have life insurance that's payable to their minor child, and they've got 401k, a 401k that's payable to their minor child. So this is a total probate estate of $1.5 million. If you add everything up, all of these assets would have to go through probate court. You take that times 5%, which is the average cost of probate, and that's $75,000. So this is how expensive it is passing away without an estate plan. So I like to make that really clear. A lot of people don't realize how expensive it is going through this probate court process, which can be avoided if you do proper planning. So this is just one example, and the 5% is not set in stone, but that just gives you an idea. And the costs for this, these are lawyer fees and court fees and things like that. And it ends up costing about 5% of the estate assets. So A lot of people are under the assumption that having a will is all that they need for their estate plan, that a will is going to kind of solve all of the problems that they're trying to solve with an estate plan. A will is not a very robust document. It doesn't accomplish very much, and one of the biggest downsides to a will, a lot of people don't realize, is that having a will doesn't mean you get to avoid probate court. It's actually the opposite. If you have a will, it has to be probated. I know it's confusing because you would think, well, isn't that the whole point of having a will, so that my assets don't have to go through this court process? And it's the opposite. It's if you pass away without a will, your estate's going to go through probate, and if you pass away with a will, your estate's going to go through probate. The only way to avoid probate court is with something called a revocable living trust. And so I want to go over what that is, because I get a lot of questions about this. A lot of people think that trusts are, something fancy that only wealthy people need. And it's really not the case. Trusts are valuable for almost everyone, once you understand what it is that they accomplish. So a revocable living trust is something that you would do instead of a will. And it's a document that you would create, and you would write into it the instructions about where you want your assets to go when you pass away. And you put all of your assets into your trust, but you still have complete control over them. So there's no loss of control. And then the benefit is, when you pass away, all of the assets that are held in the trust get distributed out to your family without any probate court involvement. So that's a really good thing. So this saves your family the time and the expense and the publicity of probate court. So remember, this big chunk of money that was lost in probate court, you're going to save a big chunk of that by doing a revocable living trust instead of a will. So that's a very broad overview of a living trust. I go into a lot greater detail when I meet people at my office or over Zoom, as the case would be now. But keep in mind that a living trust is an option, and it's the option that the vast majority of my clients choose, because it has that probate court avoidance built in. So that's a revocable living trust. So again, when you're thinking about your own estate plan, you'll have two options. You'll either be able to do a will, which will mean probate court, or a living trust, where you get to avoid probate court. And again, I just want to go over what happens if you have minor kids. If you have minor children and you haven't created an estate plan naming legal guardians for your minor kids, ultimately a judge is going to make that choice for you. So it's really important for people who've got minor kids to have these documents in place. So ultimately, I hope you can see that doing nothing, which is where many of you might be right now, which is very common, it is a decision, and it's a pretty costly decision for you and your family. So I get asked a lot why online documents are not okay for your estate plan. And what I tell people is that, estate planning is not something that you do for yourself. It's something you do for the people that you love. And if you try to do it yourself, chances are it's not going to be done correctly. The documents themselves might not be done correctly. They may not actually reflect your wishes and what you would have wanted. They may not be executed properly, especially now with everything that's going on with the virus. There's very strict formalities about how documents need to be signed and executed, or they won't be accepted by the court. At the end of the day, online documents are very cookie cutter, and they don't ask the questions that an attorney would ask. And so you're probably left with this sense of false security that everything has kind of been taken care of when it really hasn't. So I wouldn't recommend doing your estate plan online. It's probably going to end up costing you more money in the long run than it would just to have an attorney help you with it initially. So you might be at risk if you don't have any of these documents in place at all. If you have documents in place that are more than 3 years old, we always recommend that people have their documents reviewed at least every year, if not every 3 years, because your life is going to change, the law is going to change, your assets are going to change, things change, and you want your documents to keep up. estate planning is not something that you just do once and then never think about again. So if your documents are more than 3 years old, you might be at risk. And then if you haven't updated your documents and it sends any kind of a major life change, like a marriage or a divorce or the birth of a child, if you bought real estate, if you moved to a new state, these would be things that would all warrant an update to your estate plan. So if you are at risk, I would love to have you in for a virtual peace of mind planning session. We usually have these in person at my office, but now we're holding them virtually. And what we'll do at this planning session is I'll review your current estate plan, or if you don't have one, you don't have any documents in place, we'll look at the state of New York's plan for you. And we'll see how that would play out based on your family and your assets and your circumstances. And then if you'd like to see something different, we'll talk about how my office can help you get that in place. So the peace of mind planning session is normally $450, but we're offering it to webinar attendees for free through the end of June. So you can book that online at calendly.com. I have the link up here. It's calendly.com/estate plan/design. And you can book it right online on my calendar. We do ask that both spouses attend and that you fill out an online questionnaire before we speak. And what we'll do at this session again is we'll look at your current circumstances, and we'll look at whether you have an estate plan in place already or not. If whatever it is you have, we'll compare that to what you would like to have, and then we'll talk about how my office can help you potentially get that in place. So this is the link, and I think it'll be coming via email shortly as well.
Yes, we will send it. I'm going to put it right here in the chat function for everyone, but then everyone here will also get an email with that included.
Super. Any questions? I'm happy to stay and answer questions.
We certainly have a lot of wonderful questions. Thank you so much for that. That was so informative and really so clear, you know, in terms of how important it is to get these documents and really what it means, dollars and cents, and what's going to happen to your family, all those. That was so very clear and powerful. So thank you for that. So we did get quite a few questions, so I'm going to get started.
Awesome.
The first one, I own a house that my brother lives in, and he's let the insurance lapse. I'm having trouble getting the insurance reinstated. How can I protect my assets in case someone sues due to an accident? This is a different question. This is more about home insurance.
Yeah, that's
probably not your area.
I would agree. That's unfortunately not really an estate planning question.
Yeah. Who would you recommend that he ask a question of this?
Yeah.
Would it be a type of attorney? Would it be a real estate attorney?
Probably a real estate attorney. You know, my email address is up here on the screen, and if you send me an email, I'd be happy to make a referral to another attorney who could better answer that.
That's so kind of you. Thank you. We have another question here. How does this apply for green card holders who are residing in the U.S. but holding nationality overseas? How do the assets overseas apply in such instances? And also, you know, sometimes we have people who have assets who are citizens that are in America, but also have assets in other countries. How can you protect those as well? And can you?
Yeah, so you can. I mean, if you live here, you'll want to get these documents in place, and the will and the trust will cover any United States assets that you have. And then any assets that you own in a different country, it just depends on the country and the assets. So, you know, for example, if you own a home in Italy, you'll probably need an Italian will, you know, to cover that home. But it varies based on the country and the assets. So I would recommend, you know, you come in for your peace of mind planning session, and we would parse out which assets are covered under your United States estate plan and which ones would be covered under whatever country your other assets are held in.
Okay, great. And I just want to take a step back just to confirm what you're talking about is all about New York State residents, and each state has different laws governing estate planning, or
yes,
no?
that's a great point. Yep, every state has got their own laws. So I can only work with people who live in New York State.
Okay. For someone who's not married, has no children, who are good candidates for power of attorney? Relatives, friends, or professional?
Oh, that's a great question. So the power of attorney, this is the document that deals with your assets and your finances. So it's not quite as personal as, who would you want making healthcare decisions for you? So with a power of attorney, I would recommend someone that you trust implicitly to have access to your money, because you're giving this person the same authority over your assets and your finances that you yourself have. So you could even name a bank or an attorney, but just make sure that it's someone that you trust completely, to manage your money. I hope that answers that question.
Yeah. And someone else asked a question along those lines, is if you decide in a person now to assume these responsibilities, can you change the person later down the line, or is it set in stone?
Oh, that's another great question. Yeah, all of the documents that I spoke about today can be amended, they can be revoked. None of the documents that I mentioned, the will, the living trust, the healthcare proxies, they can all be changed, amended. You can swap people out, they can be updated, revoked, all that. Nothing's set in stone.
Okay. I think that's what you said about, also a good point about the 3 years, thinking about it every 3 years, maybe just even putting it in your phone and a calendar, like check in to make sure there weren't any major changes in your life that would need adjustment.
Yeah, we actually check in with our clients automatically once a year just to see if there have been any major changes in their life. So yeah.
Okay, terrific. I do have a sad question. Sadly, someone shared with us that their wife died on March 27th due to the virus. And I'm very, very sorry for the loss. It's very terrible. And he says that all we had in common was our house in the Bronx, but she had some credit card debt. Am I responsible for the debt? They didn't have a will or a trust. Can they go after their house? Again, I'm not sure if this is your area, but would a will or trust affect debt?
Yeah,
and how do you have to set that specifically?
Yeah, generally, I would have to know more about the assets that your wife had when she passed away and what was available there to pay various creditors. Creditors are paid in an order of priority, and it would depend on, what assets she had and how big they were. Again, that's something, if you send me an email, I might be able to better answer that. I'd have to know a little bit more about the circumstances.
Okay, thank you. Again, so many, it's really, again, driving home how personal all of this is, and that it's very, although you gave us such great information generally, when it comes down to planning one's estate, it really has to do very personally with their situation, their finances, etc.
Yep.
Someone asked, I currently live in the Bronx, but will be relocating to Florida at the end of the year. Will the will and trust, healthcare proxy, and financial power of attorney created in New York apply in Florida?
These are great questions. That's a great question. So one of the benefits of doing a revocable living trust is that it's valid in all 50 states, where a will is generally only valid in a state that you live in. So, if you decide to do a living trust, that would be valid in Florida, but I wouldn't recommend doing a New York will because you'd have to get a brand new one when you move to Florida. And the same thing with the healthcare proxy and the power of attorney. Those are generally state specific. So New York's got their own documents and Florida would have their own. So you might want to wait until you move to Florida, I guess is the quick answer.
That's a very important point to think about. You think you have it covered and you moved and you don't.
Right.
Someone asked, I have instructions laid out for my daughter so she knows what I do when I pass away, and I've signed it. Can this be considered a legal document?
Instructions on what the assets, where the assets are going to go, or I guess I would have to know more about if you leave instructions behind saying, I would want my guardian to do X, Y, Z, and I would want, it would be okay to spend money on private school and things like that. There's no harm in leaving those instructions behind. Whether or not they're legally binding is a different story. But I always recommend that my clients leave as many instructions behind as possible for their guardians. And you can also write into the trust document itself, for example, if you want the trustee of your children's inheritance to be able to use money that you leave behind for private school and for, for specific things, you can write that into the trust document. But I'm guessing that whatever it is that you've prepared probably isn't legally binding, but that doesn't mean that it couldn't be written into a trust document and be legally binding that way.
Okay. Now, someone asked, and I think this is a good time to ask it, is where should these documents be kept?
Another great question. So I always recommend that my clients, they go home with a big estate planning binder full of all of their signed original documents. And I recommend that they keep them at home, actually, in a place that's safe, that people can easily access. And I recommend that they tell people, I've done an estate plan, this is where I keep my documents, and this is the lawyer that I worked with. And that way, if something happens, people know exactly where to go. If you keep your documents in a safe deposit box at a bank, and then you pass away, people are gonna have a hard time accessing that. And that's the last thing that you want. So I actually recommend that you keep them at home in a safe place, and then even more importantly, tell people where you keep them so everyone knows where to go if you get sick or pass away.
And the same thing too, I think about, today with computers and everything's password protected, how important it is also for people to know what's your password.
Yeah.
Or where to find your password, or be able to access if there's, things on that aren't paper, that are electronic. So that's, important thing to think about, certainly. So someone was asking, can estate planning avoid debt collectors from taking money if it's in a trust? This person has family who likely has more debt than assets. Can it be protected, or once you leave it to someone who's in debt, does that become available to debt collectors?
Yeah, it depends on how the estate plan is written. So, if you're hoping to leave money behind for someone and hoping that that person won't then lose their inheritance to debt collectors, that would be something that we would speak about in your peace of mind planning session. I should point out that setting up a living trust instead of a will, that doesn't protect the assets in any way from creditors or anything like that. There's different kinds of trusts, and they do different things. They're not all the same. They all have different purposes. So the living trust doesn't protect your assets from creditors in any way. There are different kinds of trusts that do that. So that would be something that you would want to discuss. That's more of an advanced strategy that we want to talk about at your planning session.
Okay, great. We have so many questions. This is exciting. Let me just make sure I'm getting on to the next one. When would someone use a revocable trust as opposed to an irrevocable trust?
Yeah, so that gets back to what I was mentioning before. So the revocable trust is, the revocable living trust that you set up instead of a will, and that gives you that probate court protection. An irrevocable trust might be set up, for example, if you have, let's say you've got a taxable estate, so you've got more than, say, $20 million. That means that your estate would have to pay estate tax when you pass away. Well, one of the ways to minimize your estate tax burden is to pull some of your assets out of your estate and put them into an irrevocable trust, which is totally different from the revocable living trust. And that would help reduce or eliminate your estate tax liability. Most regular people who don't have a taxable estate don't have any real need for an irrevocable trust. But that would be one example where an irrevocable trust would make sense if you have a taxable estate.
Okay. If I do a trust, another question, if I do a trust and I leave the assets to two family members, can I guess, leave it to two family members and who would then disperse it to others according to my instructions? Is that how?
Yeah, you can write into the trust however many beneficiaries you want. I wouldn't necessarily recommend writing into the trust document, I'm leaving it to these people with the hope that they'll then disperse it, because there's no legal obligation for them to actually disperse it the way that you've written into the trust. If you want it to go to those various people, I would just leave it straight to those various people. But again, it would depend on your situation. So I would want to know a little bit more about about that. But the bottom line is that you can write into your trust whatever you want, you know, however many people you want to get the money, whatever percentages, you can write whatever you want into it, into the document.
What about someone who's a beneficiary on your 401k? Would that go to probate with a will, but not with the trust, or do they get the money regardless? So are those separate?
Yeah, so things like 401ks and life insurance, those are what we call beneficiary designated assets. So those you would have named a beneficiary when you set them up. And when you pass away, they get paid straight out to that beneficiary, unless the beneficiary is a minor. And then it would have to go through probate court because a minor can't inherit. But if you have life insurance, for example, and your husband is the beneficiary and you pass away, that just gets paid straight out to your husband without probate court. So that's not covered under your will. But if you both pass away and your children are named as the contingent beneficiary, then it would have to go through probate court because minors can't inherit.
Again, very, very specific.
Yeah.
What documents do you recommend that clients need to have handy to establish a revocable living trust?
Oh, so that's a good question. So one of the things that we do at the peace of mind planning session is we walk through all of your assets. So the most important thing is that you just know, what accounts you have and how much is in them. So what checking and savings accounts you have and what retirement assets, and do you have life insurance? And then also understanding, like, this checking account, is it owned in my name only, or my husband and I? Is it on both of our names? Those are the things that we would need to know, because we would draft your plan accordingly. So you don't necessarily have to have the documents, but you do just have to have an understanding of what accounts and what assets you have and how they're held, whether individually or in your spouse's name as well. I guess is that what they were asking?
Well, it's a good thing for the planning session to be able to talk with you and ask, what are the things I need and what are the things I need to bring together to actually get this going.
Yeah. Yeah, you won't actually have to bring any of the documents themselves to the session, but I will ask you, what accounts do you have and how much is in them and that kind of thing. We'll go over that.
Great. Is there a minimum amount you need for a living trust?
No, the only question is, do I want my estate to have to go through probate? Yes or no? And if the answer is no, then it doesn't matter if you're leaving behind $50,000, but you don't want it to have to go through probate, then a living trust makes sense. That's the question, probate or no probate.
Got it.
So I've had clients with, I'm sorry to interrupt, but I've had clients with very minimal assets who do living trusts. For example, I had a woman whose father had just passed away in North Carolina, and she had to deal with a probate court in North Carolina. And she saw, what a hassle and it was very draining emotionally. So she came in and she got a living trust and she didn't have a lot of assets, but she didn't want her family to have to go through the same thing.
It seems it doesn't matter if it's a lot of assets or a little asset. The stress is the stress. And certainly when you're in a state of mourning, the last thing you want to do is have to add stress to that situation.
Yeah.
What about a trust? Can a trust be made for a special needs child?
Another great question. Yeah. So if you have a child with special needs, it's important to draft your plan accordingly, because what you don't want is to leave that child with special needs their inheritance outright, because if you do that, then it might kick them off of any government benefits that they might otherwise be entitled to if they get an inheritance, outright, and they just put it in their checking account. So what you want to do instead is to leave their inheritance in something called a special needs trust. And that's something that we can talk about at your peace of mind planning session. What it means is that your child will be able to get that inheritance, but it's not going to kick them off of government benefits either. So that's what you'd want to do there.
Okay, that's very important. In fact, somebody else had a question about that too, and I think that answers that as well. Terrific.
Yep.
Someone said, I have many vendors set for paperless billing. How do I ensure these bills are paid when I pass away if they're only available in my email?
Yeah, so your executor will I guess access your accounts when you're gone. Is that the question? I mean,
so yeah, the person passes away and here they have all these bills.
Yeah.
That nobody else knows about because there's no paper trail. Everything's on email. I think it's like kind of a little bit what I was saying about, all the passwords and, how does one go to access all of that?
Yeah, the more information you can leave behind for your loved ones to manage these things, the better. I guess is the short answer. Passwords and all of that. I recommend that my clients, they get their estate planning binder. It's got all their documents, and then I tell them, put as much in here as possible that's going to make things as easy as possible when you're gone. So that's the best answer I can give for that is just to leave as much of a trail behind as you can. It's the responsibility of your executor to kind of clean all of that up. So they would have to do that.
Okay.
When you're gone.
We have another question about debt. If a spouse has credit card debt and but I have not signed or been designated as an authorized user on his credit card, will that affect the trust? And would I be responsible?
Yeah, generally you're not responsible for your spouse's debt, but every situation is different. But generally no.
Okay. Our next question. So if your healthcare proxy, financial power of attorney designee lives in a different state, how does that work?
Yeah, so you want your power of attorney to be someone in New York State, if possible, for various reasons. But your healthcare proxy can be someone in any state. So, keep that in mind. You can name anyone on your healthcare proxy in any 50 states, but it's easier if your financial power of attorney lives in New York.
Okay, that's good information. Give me 1 second. I keep having more wonderful questions coming in. This is terrific. What about if somebody wants their assets to go to a charitable organization? Would it be a similar setup as you would with leaving it to an individual?
Yeah, it's the exact same setup. You'll write into your documents, 10% to this charity and 20% to that charity, and you can do whatever you want, whatever percentages, whatever dollar amounts. You can write all that into the documents.
Again, especially if you want to leave it to a charity, really very important to have that in your documents because
otherwise they'll go to your family, which some people actually don't want.
Right. If you choose someone to be a guardian of your child and they agree to take on that responsibility, can you just tell the attorney this, or does it have to be something notarized and provided? How does that work?
Yeah, your guardianship nomination should be notarized and witnessed. So it's not enough to just tell your attorney, this is who I would have wanted. You really want to get it in writing and notarized and witnessed.
Okay. Another question here. If you've been named beneficiary of assets, does that take precedence over a will, over probate?
Yeah, so I'm guessing what they're asking is
for that, because do you need
well,
also like a beneficiary, like for like a 401k beneficiary?
Yes, yeah, so that kind of goes back to what we were talking about earlier. For things like 401ks and life insurance where there's just a beneficiary designation, that just gets paid straight out to the beneficiary when someone passes away. So it's not covered under your will. Your will doesn't actually, or your trust, they don't cover every asset. They only cover assets that don't have a beneficiary designation, unless it's being paid to a minor, and then the probate court has to get involved. But if it's an asset that's got a beneficiary designation on it, it'll just get paid out to that beneficiary when someone passes away.
Okay, thank you. There was one more question here that I did want to bring to your attention. Can the grantor of an irrevocable trust change it if he gets approval from the beneficiaries?
That's a pretty complicated question.
Complicated question.
Yeah, that's a little beyond the scope.
Give her a call.
Yeah.
You can go over in your planning session.
Yeah, I'm guessing yeah.
if most of your assets are assigned beneficiaries, the two main things left are healthcare proxy and power of attorney. So that will make your estate planning simple. Is that correct?
Yeah, I mean, it's, if you have, one asset and it's life insurance and you've got your husband named as the beneficiary on the life insurance, then the question is, do I need a will or a trust? In that case, probably not, because you'd have that one asset that would just get paid out to your husband. And then you'd still want to have the healthcare proxy, living will, and the financial power of attorney. That's correct. Very few people fall into that category, but yeah, if you've just got a couple of assets and they're both beneficiary designated, then you can probably get by with just having a power of attorney and a healthcare proxy in the event you get incapacitated.
Okay, thank you. Let me ask one more question. There are so many questions, Laura, that people are just thrilled to ask you. Thank you so much for your time. So someone said, now I don't know if you even know what this is, because I don't know what this is, but Aging with Dignity publishes 5 wishes. Do you know what this is? They wanted to know if it was a legally binding document or do I still need a living trust? And the reason why I wanted to ask you this is, I think there's a lot of different things that people may find on the internet. They might find through organizations that may appear to be a legal document or appear to be able to leave information that makes people feel secure. What do you say to those people who are looking at these maybe documents that they find from an organization or online?
Yeah. I'd have to look at the actual document itself. I mean, I know that, there are very strict requirements for what a court will accept as a legally binding document. Even if you hand in a will to the probate court and it looks like the staple has been tinkered with, they won't accept it, right? Even if it looks like the staple has been tinkered with. So, so I would have to look at the actual document before I would, could answer, is this legally binding or not? I'm guessing it's not, but I wouldn't know without actually looking at it. But just keep in mind that this is another reason that I don't recommend people do their estate planning themselves. There are strict formalities about what a valid will is, about how it's signed, how it's executed. Even lawyers can sometimes, get it wrong. So, you want to be careful with that, because there's no point in getting all of your wishes down and then having it be not even accepted by the court. Yeah.
Look, I think one thing, if you take one thing from this, it is, how important it is to work with you to understand exactly what you're putting in place to make sure that you really are doing what is best for yourself and your family. And because you've been so incredibly generous in offering everybody a complimentary, I just want to remind everyone, a complimentary peace of mind planning, which is normally $450. All of our attendees today are going to have an opportunity to enjoy that free through June 30th. And it's a 1-hour Zoom. So even longer than we've been on this call, you will have personally with Laura. And she'll go over your current estate plan if you don't have one. And for the state of New York, she'll discuss a plan for you. And so you can go to calendly.com/estate plan/design. You don't have to write that down quickly. It is on the screen, but you also will be getting this via email. I also put it in the chat again just now. And I really want to thank Laura so very much. This information was so valuable, and the answers to these questions, you were just so generous with your time to have such an expert of your level here with us and spend this time with us to answer questions and help us understand. We're really grateful for that. So thank you, Laura. And
so happy to be here.
Thank you. And thank you so much to all the attendees who joined us. We're so thrilled that you were able to do so. We will stay in touch with you to be able to give you more webinars in the future. And please, everybody, stay safe, stay healthy, stay sane, and plan. Make sure you plan. Have a wonderful day, everybody. Bye-bye.